So what I will be reporting today is all about free patent. So for Commonwealth, according to Commonwealth Act 141, which provides procedure for the issuance of free patents over agricultural lands, the said law uh, reference the mode of disposition of public alienable and disposable lands for long-time possessors and cultivators of such land. So under the Public Land Act, a free patent is a mode of the disposition of agricultural lands whereby an incomplete or imperfect title over a parcel of land is administratively legalized. So when we say incomplete or imperfect title, that can be the proper subject for a free patent application as per the Land Act. And it is one that arises from the continuous occupation and cultivation of the public agricultural land subject to disposition. So if you have continuously occupied and cultivated a parcel of public agricultural land subject to disposition, then you will be considered as a holding an incomplete or imperfect title over such land. Thereby, you are qualified to apply for a free patent. With the passage of Republic Act 10023 in 2010, the issuance of public or free patents is no longer limited to public agricultural lands, as residential lands may also be subject for a free patent. So, also, RA 10023 requires a shorter period of occupation of 10 years compared to 30 years prescribed under the Public Land Act. So, the new law also imposes mandatory 120 plus 5 days processing period for the applications to ensure a faster and more efficient titling process. So in this report, we will also be discussing the difference between the residential free patent and the agricultural free patent, as well as the requirements and qualifications. So a residential patent is issued to public lands that are zoned as residential and occupied for at least 10 years, and as well as subject to applicable area of limitations. While agricultural patent are land grants awarded to natural-born Filipino citizens in actual occupation and cultivation for at least 30 years of alienable and disposable lands, not more than 12 hectares, and have paid the corresponding real property taxes. So now we will be discussing the residential free patents through the Republic Act 10023, or an act authorizing the issuance of free patents to residential lands. So what are the qualifications to be able to apply? So it must be any Filipino citizen who is an actual occupant of the residential land for 10 years may apply for the free patent. So please note here that it must be an actual occupant of untitled residential land, using it as his or her actual residence, and have continuously possessed and occupied such land under a bona fide claim of ownership. So it must be noted that in order to qualify, you must be an actual occupant of the untitled land and is actually residing in it. So there are three keys for that. You must be an actual occupant, place of residence, continuous possession, and has a bona fide claim of ownership. So for the coverage of this, the land that is applied for must not be needed for public use. So the land shall cover all lands that are zoned as residential areas, including town sites as defined under the Republic Act. So zoned residential areas are also located as inside the delisted military reservation or abandoned military camp, and are those of local government units or town sites which preceded the Act 7586, or National Integrated Protected Area System Law, shall also be covered in the Act. So the area for the coverage for the lands is indicated in this table. So for highly urbanized cities, land maximum area is 200 square meters. So other cities is 500 square meters. First class municipalities is 750 square meters. Second class is municipalities 750 square meters, as well as other municipalities is 1,000 square meters. Okay, so under RA 10023, also discussed the special patents. Just a note here that notwithstanding any provision of law to the contrary of any subject to private lands, if any of the public land occupied and is used for public schools, municipal halls, public plazas or parks, and other government institutions for public use or purpose may be issued special patents under the name of the national agency or LGU concerned, provided that all land titles under this section shall not be disposed of unless sanctioned by Congress if owned by the national agency or sanctioned by the Sangguniang concerned through an approved ordinance owned by the LGU. So it's not within the free patents, but this will be issued as special patents. So for the application, so you must need a map based of the actual survey conducted by a licensed geodetic engineer and of course approved by the DNR. Aside from that, must also provide a technical description of the land applied for, together with supporting affidavits of two disinterested persons who are residing in the barangay and the city or municipality where the land is located, attesting to the truth of the facts contained to the application to the effect to the applicant thereof, either by himself or through his predecessor in interest, actually resided on and continues possession and occupation under a bona fide claim of ownership. And of course, land must be occupied within 10 years as requirement. Okay, so this is like the initial process for application. So of course, you go through the SENRO. There's the interview of the applicant where his ownership is going to be discussed, payment of fees, inspection, you have the compliance with all the requirements and the forms needed, formal acceptance, posting of notice, submission of their reports by SENRO. So, of course, there's a process if it's denied, if it's approved, it'll go smoothly, then it will be forwarded to PENRO if approved. And then, of course, it will be transmitted for the registration of deeds. So basically, the first initial step would be to go to SENRO. After approval from the SENRO, it will go to PENRO. And then after that, it will go to the registration of deeds. Okay, so as I've mentioned, first is the application at SENRO. And then after that, SENRO will have 120 days for the compliance with the required notices and other legal requirements, then forwarded to PENRO, who shall have 5 days to approve or disapprove the patent. And in case that there will be issues such as conflicting claims among the claimants, the parties may seek proper judicial remedies. Okay, so who will be the implementing agents of this free patent for residential lands? It will be the Director of Land Management, Bureau of the Department of Environment and Natural Resources shall promulgate the rules to carry out the provisions and shall see to it that such it's so gender responsive. That's there indicated in the implementation. So if the lands covered by free patent was a private land, the Director of Lands has no jurisdiction over it. And if the Director of Land has no authority to grant patent to lands that have ceased to be public in character and have passed on to private ownership. Okay, so let's just have some FAQs or common questions regarding residential free patents. So as I mentioned a while back, actual occupant. So who is considered an actual occupant? So it is any person who is occupying, living in, or staying in a structure situated on a residential land which serves as the residence of the person. So how long should you be occupying the land before you can apply for a free patent? Must show occupancy within the last 10 years in order to be entitled over the residential lands. So who are considered a predecessor in interest? So a predecessor in interest is a person who has formerly occupied a parcel of land in the concept of an owner under a bona fide claim of acquisition or ownership, but resigns his or her right over the same in favor of an applicant. So lawful transfers of land may be through contract of sale, execution, deed of donation, and other similar acts of disposition. So for example, your predecessor was your, um, let's say, parent, and then you are now the actual resident of the land, then you can still apply for the free patent. Or if, for example, the previous owners sold the land to you, and you've been, of course, they've been residing there for more than 10 years and you as well, then you can still apply for a free patent. Okay, so what does an actual residence mean? So remember, these are the three things that were repeated during the what qualifies, or what are the requirements to be able to apply for a pre-patent. So actual residence means that you intend to use and are or actually using, or the structure in that parcel of residential land subject to your application is your place of residence. It is not necessarily that you use the residential area as your residence continuously, but this continuous use of residential land does not necessarily mean that there's no longer your actual residence. For as long as you intend to use the same as your place of residence, the residential land can still qualify as your actual residence. So this is just to describe it. It does not really contrary to the actual occupancy or possession. So it just means that, for example, you've been living there because, your actual, for example, us, if I'm an actual resident of Tabuk and I just moved to Manila for work for about a few years or so, but my actual residence is still technically Tabuk, then I can still apply for the free patent here. Okay, so what is a bona fide claim of ownership? So this means that an applicant has a bona fide claim of ownership if he or she provides a legally acceptable proof of possession of the land, and the community must recognize that the applicant is the owner of such parcel. Also, if I am a minor or 18 years of age, can they apply for residential free patent? So DNR says yes, minors may apply for residential free patent. There's no age requirement to be qualified as an applicant. However, if you are 18 and below, you have to have you have to have be duly represented by your guardians. So guardians could be mother or father of the minor, or in case doesn't have parents, the court may appoint a guardian of the person or the property, or both. And also any surviving grandparent, oldest brother or sister, that is actually above 21 years old. They may also serve as custodian or guardians, or basically any person the court thinks would serve the best interest of the minor if in case the immediate relatives or the parents are not available. So DNR allows a minor to be represented by a person of legal age if in case the applicant is a minor. So what are documents to be submitted? These are the initial documents to be submitted. The details of the specific documents are actually in the DNR website. It's posted. There's also a link there I will be giving at the end of the slides. But just to have an idea, to apply, you need the residential free patent applications, the accomplished forms provided by Senro, copy of the DENR approved plan or copy of the cadastral map showing the parcel of land applied for, copy of the technical description, simplified sketch, two affidavits of disinterested person, and certificate of no pending land registration proceedings covering the land applied for from the regional trial court, and the other checklist of requirements of residential patent as listed in the DNR Memorandum Circular number 11 to 10. So if you notice here, what is the purpose of the two affidavits of two disinterested persons? So as I've mentioned, you need an authority or a recognition from either the barangay or the municipal or the people within the area to give or provide a proof of your residency or that you've been staying in that property. Okay, so now we move forward to agricultural land. free patent. So the free patent is a mode, as I've mentioned again, the free patent is a mode of acquiring a parcel of alienable and disposable public land, which is suitable for agricultural purposes through the administrative confirmation of imperfect and incomplete title. So agricultural public lands are classified as alienable and disposable and are subject to disposition under free patent. Okay, so to be entitled for a free patent, a farmer must be a natural-born Filipino citizen and in actual occupation and cultivation for at least 30 years. Must be a continuously occupied, possessed, and cultivated the land by himself or through his predecessor in interest. Predecessor in interest has the same definition from that was discussed before from the residential free patent. So, and also has paid the corresponding real property taxes. The land qualification must be an alienable and disposable land, and not more than 12 hectares, and for agricultural land or purpose. Also must be a public land, of course. Okay, so how does an agricultural free patent differ from that of a certificate land ownership award or the CLOA? So an agricultural free patent comes from the public lands, while CLOA comes from private lands distributed by the government under the Agrarian Reform Program. So that is the main difference. So it shouldn't be confused. So CLOA is from the Agrarian Reform Program, or the CARP, Comprehensive Agrarian Reform Program, while while agricultural free patent is from the Public Land Act. So what are the agricultural requirements for agricultural patents? Again, you have here the duly accomplished forms, tax declaration if available. If in case there was a sale or deed of sale, extrajudicial settlement, waiver of rights. These are it varies from situation for the requirements, but this is just an overview. Certification from the municipal circuit or regional trial court concerned that there is no pending land registration case involving the parcel being applied for. That is very important, of course. As I've mentioned, if there's any dispute of claim of ownership of over the parcel of land, then it must go through a different proceeding, not the usual application for a free patent. And of course, the approved survey plan with technical descriptions, or the Form V37 covered with isolated survey. Certification of status of the land and from the Land Registration Authority. If the municipality is under cadastral proceedings or if there's an old survey, the property can also attach that. And the certification that the land that you applied for is alienable and disposable, as well as documentary stamps necessary. Now we go through the removal of the restrictions. So under RA or Republic Act 11231, it is the act of removing restrictions imposed on the registration, acquisition, encumbrance, alienation, transfer, conveyance of land covered by free patents under sections 118, 119, 121 of Commonwealth Act 141, otherwise known as the Public Land Act. So if you track this one, the of course the free patent originates from the Public Land Act. Now under the Public Land Act, there were restrictions imposed, but with RA 1123, those restrictions imposed specifically on sections 118, 119, and 121 were removed. Now let's discuss further. So under RA 11231, the agricultural lands or agricultural public lands alienated or disposed for in favor of qualified public land applicants shall not be subject to restrictions imposed on the registration, acquisition, encumbrance, transfer, or conveyance of the lands under the Public Land Act. So what are the restrictions that were removed? So these are the restrictions as follows: the 5-year prohibition on encumbrance and alienation, the 5-year right to repurchase, and prohibition on corporation, association, or partnership to acquire or own an agricultural land. So what does this exactly mean for a farmer? Okay, so the reason why these restrictions were removed is to empower the millions of free patent holders who, prior to this, could not freely use their land as capital asset due to the restrictions. Also, the state is easing up its policy on restricting transfers and repurchase of public land grants. Other reasons are for restrictions deny access to formal credit market. Landowners are more likely to sell their lands in the informal market at a cheaper price, and government loses revenue from taxes and fees because of informal market transactions. So they want to make the market transactions legalized. Kasi for example, if you have a free patent and you're a farmer and gusto mo siyang gawing collateral instead of for example collateral because you need it, instead of going through a legalized market because you are restricted or it's not possible, you sell now your free patent for a very, very lower price to someone else, for example. So nawawala yung, or the value for the purpose of your usage of your free patent is not maximized. So that's why they remove the restrictions. Now let's have a question and answer to elaborate further on the restrictions. So for this, if for you have a free patent, are you able to sell this? So yes, a farmer now holding an agricultural free patent may now sell their land and use it as collateral after the signing of the act by President Duterte. And it is a measure that removes the Commonwealth era restrictions on lands covered by the Public Act. So the Public Act, the RA 11231, has a retroactive effect, and any restriction regarding acquisitions, encumbrances, and conveyances, transfers, or dispositions imposed on agricultural free patents issued before its effectivity of the act shall also be removed and lifted immediately. Of course, provided that the act shall affect the right of redemption under Section 119 of Commonwealth Act 141 as amended for transactions made in good faith prior to the effectivity of the act. Okay, so if I have just sold an agricultural free patent, can I still buy it back? Yes, for transactions made before the effectivity of the law, you still have the right to repurchase it. So as I mentioned, RA 11231 is retroactive. So it means that agricultural free patents issued before the law is passed will also be free of restrictions. For example, you were issued a free patent, let's say 5 years ago, it means, or let's say more than 10 years ago, let's say, then it's still effective. The restrictions lifted from RA 11231 will apply. So will the removal of the restriction lead to land conversion? The law will not affect land use because the land conversion is covered by a separate laws and policies, namely RA 6657 or the Comprehensive Agrarian Reform Law, RA 8435 or the Agricultural and Fisheries Modernization Act, and Department of Agrarian Reform Administrative Order 10 of 2002. Okay, so for the application of free patent, before it was until December 31, 2000, but RA 11573 was passed, which removes the deadline for agricultural free patent application and also reducing the required period for land possession. So it's approved by President Duterte on July 16, 2021 rather. So the deadline for agricultural free patent has been removed and shortened the required period of possession for confirmation of imperfect titles of 20 years to 20 years. So from 30 years, it becomes 20 years now. Okay, so filing and acceptance of agricultural free patent applications in Senro offices nationwide has stopped just December 31, 2020 rather. So pursuant to RA 9176, that was the old deadline. But with the new deadline provided in RA 11573, the DENR or the Senro has accepted agricultural free patent applications, as well as the process has now been simplified. I checked on the website, there's no specific deadline provided as to the end of the or if there's any deadline imposed towards the application for free patents. Perhaps we'll have to wait the next few months or year or so if they will be issuing any specific deadline. But for now, it doesn't really included there when they will stop the application. It just says there that they have resumed the application process for agricultural free patents. Okay, so how do you apply for agricultural patent? Again, there's a checklist of documentary requirements that you have to go through or you have to accomplish. Okay, application of free patent and prescribed forms, document showing identity of the land, proof of claim of ownership. This could be, let's say, the tax declaration, certified true copy of approved survey and cadastral map, technical description, certification from the RTC concerned that there's no pending registration involving a parcel to be applied for, certification of the land, certification of status from land from LRA, or if the municipality is under cadastral proceedings, or if there's an old survey, documentary stamps, payment of application fees, and all that. So what is the process for the submission of agricultural lands? So of course, the application, duly accomplished application forms must be submitted, payment of corresponding fees, submission of the official receipts to the land management inspector, then to the deputized by public land inspector for inspection. And then there's the posting of notices, 15 days posting by the LMI and DPLI. Then it will be forwarded to certified lot data computation, the order of award, judicial form to geodetic engineers, and then the geodetic engineers will forward the verified and certified correct technical description to the Chief RPS. Chief RPS provides it to Senro. Senro will initiate, file copy of patent and sign endorsement to Penro for approval. Okay, so once it is in the Penro, the Chief Technical Service Division will perform the final review of the CARPETA initial file copy of free patent forwarded to Penro for approval of the application and issuance of patent. Penro will now sign the order of approval and free patent, then goes to the records section for indexing, and then of course it will be transmitted to the registration of deeds. But the first one, or the most important, if you are, let's say, for a farmer, this may seem a lot of application process, which it is, but the first step would always go to Senro, have all the duly accomplished forms, and provide the proof of ownership, or you have to prove your bona fide claim of ownership in your actual residence, your actual dealing or possession of the property. So it's pretty much the same as the residential application, but of course, since this is agricultural land, there might be other or difference on the application process. Okay, so all the checklist of the documents and the processes can be found on the DNR website, which is online. So at least if in case there will be an application, then you can go through it one by one. So that ends my report for the free patent. Thank you.